Welcome to Q&A. I'm Kendra Cooper, your host and a Massachusetts attorney. Today's discussion centers around Melanie's Law, Massachusetts legislation passed in 2005. Melanie's Law was triggered by a tragic accident in which a 13-year-old girl, Melanie Powell, was killed in 2003 by a drunk driver as she and her friend walked along Route 139 in Marshfield. Her grandfather, who described Melanie as a soccer player, a Girl Scout, a cheerleader, everyone's little girl, spearheaded the effort at the State House to toughen the penalties for repeat drunk drivers. At the time, the Registrar of Motor Vehicles, Kimberly Hinden, said, "The toughest provisions of Melanie's bill will not impact average citizens. You will not be unjustly penalizing your next-door neighbor for having a beer after the ball game. You will be imposing the appropriate criminal and administrative sanctions on people who have gone through the system time and time again." That was the furor and the call for action that the Massachusetts legislature heard in 2005. As criminal attorneys, who have practiced for several years, how have you seen the intent of the legislature play out? And my guests today are Jay Milligan, to my right. Jay's been a longtime criminal attorney and specializes in OUIs in Massachusetts. And Mark Stevens also is a criminal attorney, very experienced, and he practices both in New Hampshire and Massachusetts. So to get to Melanie's Law, what have you seen? Because now it's been in effect for at least 5 years. And I think, Jay, you've had a lot of experience in this.
I have, and I wish Ms. Hinden's statement to be true, but as it turns out, the application of this law has anything been that. What a lot of people don't realize is Melanie's Law, as it was drafted, tied into some existing laws that nobody really knew about or had cause to know about. The first one being a lifetime look back in Massachusetts. That was enacted in 2002. And what that law basically said is, if you have any OUIs in your past, whenever they were, the 50s, 60s, 70s, and you pick up an offense now, we can treat you as a second offense. That law is tied into Melanie's Law in a number of respects, not only in enhanced penalties. One of the sweeping provisions of Melanie's Law was the ignition interlock device in vehicles for second offenders. And what people don't realize is they're counting all those offenses in the 50s and 60s. So you may have a next-door neighbor who had an OUI in 1960 and goes out and has a beer at a ball game for whatever reason. They get pulled over, they get arrested. They are going to be subject to Melanie's Law. So the application of it, both in the registry and in the courts, it's not quite what they made it out to be in 2005. Obviously, it was surrounding a tragic event, and unfortunately, we make laws basically around tragic events, and a lot of things get done and they don't think them through. And Melanie's Law was one of those laws where a lot of things didn't quite get thought through. And the issue with it is you don't have, district court practitioners or OUI lawyers weren't consulted with the ramifications of this. They consult with parents, with court personnel who don't necessarily do this stuff day in and day out. And most of these legislators, while lawyers, most of them haven't stepped foot in a district court and wouldn't know how these provisions are going to affect lawyers, judges, staffing personnel in courts. This law has had an effect on all of this and how we handle cases, in other states. It really has had a dramatic impact on how we do things day in and day out in handling OUI cases.
There's been a multiple reverberation of effects then.
And it's still going on. These issues are still being fleshed out, not only at the registry level, but in the courts. And a lot of people don't realize the ramifications of what they've done 30, 40 years ago, and they enter into pleas or agreements with the government. They say, hey, this wasn't what I bargained for. Well, they say, well, Melanie's Law says this, and nobody knew it. Nobody knew what was going to happen to them, and here they are now trying to fight it and trying to get out from underneath what they bargained for.
How are you seeing that impacts New
The way that it
Hampshire and
impacts us is
Massachusetts?
about half of our clients are from Massachusetts. I'm right on the border in Salem, and half are from Massachusetts and half are from New Hampshire, roughly. The Massachusetts driver who has an OUI on his record and still has a Massachusetts license almost has to fight every case that he's charged with, whether it's a strong case, weak case, or somewhere in between case, because the registry consequences for that person are so severe that even a 25, 30, 40-year-old OUI conviction is going to come back and bite them, or a 20, 30, or 40-year-old quaff even, continuous without a finding. So the Massachusetts driver is put in a position where he or she almost has to fight an out-of-state conviction because it's going to come into the registry as a conviction, and they're going to treat it as a second offense.
I mean, I don't think people understand that they can look back that far, and that even there's anything in computerized records that show.
Well, they can find it, and they do. And
Right.
you find people who got in trouble when they were in college, they're 18, 19 years old, and now they're 50 years old, and their life is different, they're in a different place. They're hardly what you would consider a serial OUI repeat offender. They are the person who lives next door to you, like the registrar said, you know, that it wasn't going to affect. It does affect them, and we see it every day.
I was thinking about some of the people I know. Now, when I was in college, you know, there were very different attitudes, and I'm surprised that this is almost looking back that far, it's almost holding people accountable who were in their 60s or even 70s now, when, you know, for actions that occurred when they were while they were in college or in teens, and there was a different attitude towards alcohol in the 1950s, 1960s.
And the penalties were different too, Kendra. You know, you look at what would happen to them as a very short license loss, not much else. There wasn't a great deal of thought put into going in and pleading guilty to an OUI offense in Massachusetts in the 60s or 70s, because you know, nothing really bad happened to them. It was a continuous without a finding. There was no criminal conviction out of it. But now it's coming back to bite them, and there were cases that probably should have gone to trial way back when that didn't, because the penalties weren't that bad, and the people at the time that they pled didn't know that this was going to come back and bite them decades later.
And the worst part about it is people have made a constitutional term ex post facto challenges to these registry issues, and what they've said is that registry actions are not punitive. They're remedial in nature, in which case ex post facto does not apply.
Can you explain the ex post facto thing? Because I know people aren't going to
well,
understand what that is.
I have to go back to my constitutional law days in law school, but basically that, you know, they're taking a law and they're changing the penalties for which someone would, using a prior offense as a predicate offense and penalizing for that now, and particularly with the registry stuff. And they're saying it's remedial, and at least for, I know Mark and I, when my clients come to me, their major concern is, what is my license loss? What is it going to be? How long am I going to be without my license? And what am I going to have to do? So that is the most punitive thing in anybody's life. If you think about it, that's that's your livelihood, that's your family, that's your job. So to say it's remedial, I think is, you know.
But what kinds of things change? Besides the look-back law, which is much further back than anyone could imagine, that they'll now be held accountable for actions that at the time that they did them, they had no idea they were of the serious nature that they are now.
There were a number of changes. One of the first changes that we see on a daily basis were refusal suspension. When someone is arrested and they refuse to take the breath test, those suspensions have been ramped up considerably.
So what happens if you refuse the breathalyzer right now?
For a first offense, you lose your license for 180 days. Now, for a second offense, now including one in the 60s, it can be taken away for 3 years. A third offense, 5 years, and a fourth offense is a lifetime. And candidly, if you have 4 prior OUIs, a lifetime suspension may be called for. But the issue being is if you had one in the 50s, 60s, and you refuse the breath test, and even the police don't know, they won't advise you specifically what your license suspension is going to be. So the issue then becomes whether or not someone is knowingly or intelligently making a decision on whether or not to take the breath test based upon a suspension. That was one issue that was changed with Melanie's law. There was a child endangerment statute that was enacted, which basically had indicated if you're operating under the influence of alcohol with a child who's under the age of 14, that was an enhanced penalty. They implemented a manslaughter provision, obviously in operating under the influence of alcohol, causing death. And the only real change in that was just the penalty was enhanced. And the license suspension went from 10 years to 15 years. There were other provisions for operating, obviously, with the implementation of the ignition interlock devices, penalties for that if you drive without it. But The main changes, the major changes had to do with the ignition interlock device and the refusal suspensions.
There was also some changes too as far as how youthful offenders were handled or are handled now.
Yeah, I mean, the youthful offender, you know, I'm all for keeping young adults who get their license in check, but the way they have done this now is essentially speeding tickets, 90 days, and it's expensive. You're talking $500. These kids don't have the money. It's coming out of the parents' pocket. They have to take a remedial driving program, which I am all for. But there are things that could have been done short of penalizing these children financially. 90-day suspension, even sometimes 6 months on some of these offenses, is a long time to be without a license. And it's not the kid who's penalized, it's the parents. Because then the parents got to get them to their sporting events, the parents got to get them to work, the parents got to pay all the money because they can't go to work. It just, in my assessment, it could have been thought through a little bit more on how you penalize a young adult who's driving.
Yes.
And the thing with that too is that you penalize the parent, you take the kid off the road for 180 days, you're not making him or her a better driver by taking someone who's had a license for 6 months off the road for 6 months. If anything, it's quite the opposite. You know, a program or a safe driver program or something like that instead of the license loss, and certainly instead of in this economy a $500 fine for a speeding ticket for a kid that age, it's
Do you think that they even are aware of it? One of the
not
things that
before it
bother me
happens.
is before.
It's not until they come to see one of us that they find out what's going to happen to them.
What kind of educational program is there out there so that people know? I mean, that's part of why I'm doing this program, because I don't believe that being extremely punitive is going to work if people, as a deterrent, if people don't even know it. Only once you get in the system do you begin to realize that, wait a minute, there is this law that has a lot of really high fines and loss of license. And it's almost like a gotcha mentality instead of a preventive mentality.
Well, it's the same thing with the OUIs now, but you know, I would hope that the driver's ed teachers are you know, at least informing them, but my guess is they're not. You don't know.
Well, see, I think if Melanie's law is the way it is, and it appears to be, that there really needs to be a component in driver's ed that really comes in hard and explains that this is what the penalties are, this is what happens, and
Well,
that they are starting their own.
I think they do. I speak at one driver's ed course, and you know, we talk about the not drinking and driving and what some of the penalties are for different types of common offenses. But the kids are in high school at that time, they're learning lots of things. And the point that they get their first speeding ticket would be a good time to just maybe send them to a safe driver course to reiterate that, teach them how to use the cruise control, teach them how to focus on different things and not changing their CDs and stuff that they're going to do. But fining them $500 doesn't do them any good. And suspending their license for 180 days, if anything, makes them a worse driver by the time they get back on the road. So.
But they are laying the foundation for their lifelong record, just as older people, you know, have laid it and didn't even know it, you know, when they were in college. I mean, how do you feel about that? Are you seeing
when you
that?
go to the registry, you talk about driving histories. And the history is just that, everything you've ever done with a license. And if you start off as a young adult with a license, picking up speeding, driving dangerously, erratic operation, this stuff is going to follow you literally for the rest of your life. They're going to see that. And God forbid you get in some more trouble as years go on, that history is going to follow you around. They're going to have that at any prosecution. They're going to get your driving history, and they're going to see that you're not a safe driver.
When a policeman pulls you over, that is pulled up? I mean, say if someone was driving in New Hampshire and either were speeding, what comes up, and what is the likelihood that that also have an impact on whether they give you a ticket? Or I'm just wondering now with the technology the way it is.
There's an interesting thing about a Massachusetts driving record is that things you're found not guilty or not responsible for show up on there too. So when we get a Massachusetts driving record in a New Hampshire case, it's pages long, sometimes 3 or 4 entries, one taking the license away, another one giving it back, some responsible tickets, some not responsible tickets. In New Hampshire, these eventually drop off. In Massachusetts, they follow you to the grave. Anything you've ever done, anything you've ever done on the road is going to show up, and you see people with relatively.
Even if you're acquitted.
Yeah, even if you're acquitted, they show up as not responsible, and it's difficult sometimes to explain to New Hampshire prosecutors why something would be on a record if the person was found not guilty of it. But you've got to go in and explain the codes to them. So especially with a young person, they've got to realize anything they do is going to follow them right until they get buried in the grave, and they've got to be very careful with what they do when they're charged.
And not just in Massachusetts, or not just in New Hampshire.
Okay.
You know, the states have become, you know, fortunately or unfortunately, the states have become very adept at communicating. So I know that anything that happens in New Hampshire with a Massachusetts, with one of my clients, is going to come back. The same way Mark knows if one of his New Hampshire licensed clients does something in Mass, it's going to get to New Hampshire. You know, and that becomes part of your history. So it's not just what you do in Mass, it's what you do in other states. And that's another thing that people don't realize. They go to New Hampshire and get a DUI up there and say, well, I'm just going to plead to it. You know, 2 months later, they get a notice from our registry saying, you know, guess what? You just pled to an OUI. We're going to take your license for a year. I almost assure you, without a lawyer, that person did not, and even with a lawyer, most of them don't know that. So
you're saying New Hampshire attorneys don't necessarily understand the implications of these kinds of infractions?
I would say some New Hampshire attorneys perhaps don't understand the license ramifications that will occur here with a New Hampshire licensee.
I know one that does.
I know Mark does. Just by virtue of the number of calls I get.
Yeah.
You know, so it is happening. You know, it's unfortunate, but at that point, it's too late. There's nothing I can do for you. You've already dug the grave. You've jumped in it, and now it's just damage control at that point and what I can do to try and get you back on the road. And it's there forever. It's not going away. So God forbid, 10, 20 years from now, you get in another problem. Melanie's law is going to kick in, and who knows what the laws are going to be in 10, 20 years. I guarantee you they're going to be tougher.
We had a case, I just had a case where a person pled to a DWI when they were 18 or 19 years old. They blew a .02, which is the per se limit. Went in and pled guilty without a lawyer, and now has one in Massachusetts open, so they're charged with a second offense. And a .02 is nowhere near close to being impaired, but the law says a .02 is a guilty.
But a .02.
Now, if you hired a lawyer that could read and write, you're not going to get convicted with a .02. But if you go in and plead it, this thing is now chasing this person, and he's into his 30s or 40s. So it's something that you've really got to be careful about. The young person, we tell them, you should almost always fight your DWIs because these things just get such long-lasting and deep ramifications.
DWI is driving while impaired, right? I mean,
right, it's the same.
I'm just saying because OUIs and DWIs, people, you know,
it's the
may
same
not know.
thing.
It's the same thing.
It's wicked bad if it gets on your driving record.
Right. Now, and you could just explain a little bit, like a .02 is if you're a youthful offender, then that is the limit in Massachusetts. I mean, that's one of the things with
we have. Yeah, I mean, yes,
just
we have.
Explain a little bit about what these numbers are that you're just using.
There are separate. There's a separate provision of the statute called the Junior Operator Law. So if you're, and it's broken up into different ages, so 16 to 18, 18 to 21. If you get arrested and refuse to take the breath test and you're 16 to 21, it's a 3-year suspension. 3 years. There is an additional administrative suspension depending upon how old you are. It can be for 6 months to 1 year. You have to enter into and complete an alcohol education class. There's supposed to be a youthful alcohol education class or youthful offender alcohol. They never created it. So now these young adults are entering into the same program that the adults enter into. It defeats the whole purpose of it. You got these young adults coming into a class with mainly people's in their 30s, 40s, 50s. It's not geared towards the young adult. So that's a main change that Melanie's law did implement.
You mentioned the youthful offender program. Now, I thought that was supposed to have kicked in January of 2006. We don't have it? Because that was there's an integral part of Melanie's law, supposedly.
There is a statute called, Mass General Laws 90, Section 24P. Right. That is the statute with which someone in that age, 16 to 21, has to enter into and complete the alcohol education program. There is no 24P program. It doesn't exist. So what they've done is taken an existing program, which is a 24D program, which is for anyone who's caught with an OUI. Anyone has to, who pleads guilty or is found guilty on a first offense must enter into this program. It's not geared towards young adults in driving behaviors and consumption of alcohol. It's geared towards the general public, and I'm sure they get something from the class, but they're not necessarily with their peers.
So
which I think was the purpose behind having a 24P program.
And that was part, that was part of the intent of the legislature when they passed the law, or this is something that was added afterwards? Or?
24P has been there for a long time. I think it was always the intent to implement a separate program, whether it's funding or inability to do it. I'm not quite sure as to the reason why it wasn't done, but there's never been a program, as long as I've been practicing in 11 years, there's never been a 24P program. And I think it's, like I said, I'm sure they get something out of the program. I think it would be something
effective.
More if it was with their peers and there was more of a open discussion on specific problems with young adults in drinking and driving.
And how to prevent these kinds of things from happening. Is there anything like that in New Hampshire? Or?
No, not really. There's no youthful offender program. They go to the same adult program as everyone else. And you know, as an educator, as a 16 or a 17-year-old interacting with people in their 40s and 50s, it's not going to happen.
Yeah.
It's not going to happen. So
well, they're coming from different perspectives.
The different perspective, the different peer pressures that they have, that teenagers have that adults don't. I think that they're going to clam up and not going to get as much out of the class as they would if it was a peer type of group. But we don't even have a fake program like that. Or a law that says they've got to do it. We don't have any such program. So.
One of the components, I believe, of Melanie's law was implementing these interlock, ignition interlock devices as one of the penalties. And can you kind of explain how that is, what that is, and how it's working? Or?
I can. The ignition interlock device is basically something. It's a very small device that will attach to the dash of your vehicle that is then attached to the ignition of your car. In order to start your vehicle, you have to blow into that device and register a .02 or lower. It will then start. At various intervals while you're driving, it will request you to submit further samples. And obviously you have to be below that .02 level. If it's above that, it's not going to shut the vehicle off, but it will record it. Every 30 days, someone has to upload this data at a service center. They're private businesses that the state has approved. The data gets uploaded directly to the registry, and if you have some issues, the registry may call you in to explain what was going on with your particular device. The length of time with which someone might have this depends upon the number of the offense, but essentially the way it works is you have to have this vehicle, this device in your vehicle for a minimum of 2 years from when you get your full license. So when your hardship license ends, which can range from anywhere from 45 days to 8 years, depending upon the offense, or 10 years, depending upon the offense, plus 2 years. So people who are subject to this can have this in their vehicle for an extended period of time, and it's expensive. It costs about $125 to install, about $85 to $90 a month to maintain it. So it is a very costly device. I agree with the concept. I agree with the theory in it. I don't necessarily agree with who it's being applied to now, specifically that person who has that OUI in the 50s, 60s, 70s, and now has one. That isn't what Ms. Hinden had suggested, someone who's in the system time and time again. That's certainly not what she meant by that statement, and I can be sure of that. So it's expensive, and it's not necessarily the best device in the world. Again, I agree with it, but they are susceptible to false positives, so you have people who were called into the registry to answer for something that they haven't done. And the registry's not really understanding the process, or the device for that matter, as far as I'm concerned. But so it can be a problem.
Have there been studies about the accuracy of this? In other words, what percentage of these errors are false positives, for example? I mean, I've heard something about pepperoni pizza can trigger this, and I'm just thinking, what kinds of things can trigger the false positives?
I mean, all that I have is anecdotal evidence from clients. And some of it has actually been backed up by clients. For instance, the pepperoni pizza was one of my clients who fortunately worked in a hospital. He was a maintenance individual in a local hospital in Boston, and he had to go from facility to facility to facility. Fortunately, he went and got a blood test. He was smart. And the blood test registered .00. There was not a lick of alcohol in his system, and this device read, I forget what the number was, but it was well over a .02. I think it was in the 0.05, 0.06 range. I've had other clients who literally walk into police stations after blowing .05s and saying, this device just said I'm drinking. I am not drinking. So the advice is, so what the margin of error is, that depends upon who you talk to. But they certainly are susceptible to false positive. And you got to remember, they don't have the regulations that are in place for a state breath test. There's no second sample. There's no calibration of it. It's a single test method, which is documented an unreliable method of testing. But for this purpose, it's the only method of testing, so they just use it.
There aren't other states that have something that, you know, in other words, is there something in other states that works better than this?
No, there's only a handful of manufacturers that make these things, and all the states, you know, use them. They approve the same gizmos and the same testing methods.
And is there a problem in trying to find out the trade secrets behind it so you can understand how they work?
Oh, sure. The manufacturers don't want you to know how these things work or don't work. That's what they don't want you to know, is how they don't work. And if there's ever going to be a problem with one of these things, you're going to only find out about it when somebody like Jay's client has the wherewithal to get a blood test. Most people don't. It's hard to walk into a hospital and say, here, I got to get this done quick.
See, well, is there, you know, is there anything that you're really seeing a lot among your clients or yours, Jay, that you really believe people misunderstand, you know, about Melanie's law and about how they're going to be held accountable either now or later on? Or
the one thing we see is that they're more likely to fight a case. They're more likely to try a case because of their past, their history. Even though the history might be very, very attenuated 20, 30 years back. I don't think that's what they meant when they passed Melanie's law, was to punish somebody who had a very low-grade minor OUI, cough or something when they were 18 years old. Now they're 48, and they've got another marginal OUI case that ordinarily would have pled before Melanie's law and now can't. So we see a lot more cases going to trial and advise people to try more cases that in the past might not have had to go to trial with the Massachusetts license holder.
And just to reiterate, it's the same thing. I mean, with us, with the lifetime look back, coupled with Melanie's law, there's very few things that people want to do that are going to stay with them for the rest of their life, you know, other than your marriage and your kids, perhaps. But so our clients are fighting them, and some of them don't want to, but given these penalties and where they may go, that they feel like they have no choice but to fight these cases, and it results in more trials in the court and
more congested
court systems. So.
Yes, and people just have no understanding that they may be held accountable. I think that's what I've been concerned about with Melanie's law. We all, you know, hate to hear about these tragedies that happen, and none of us want to be on the road with a drunk driver. But at the same time, you know, people need to understand that this is what's out there, and there probably are ways we could improve the law so that at least it is something that you know, people will at least understand. But anyway, I really appreciate your coming today and discussing this topic with me. I've wanted to discuss it for a long time, and we just haven't been able to get together.
Thanks for having us.
But you're welcome. I'm your host, Kendra Cooper, and I thank you for watching.